Welcome, students, to this Essential Explainer. Today, we're adopting a strict academic focus. We're looking directly at a very common KSLU University syllabus question. Explain the rules regarding delivery and acceptance in performance of contract of sale. I need you to pay close attention because understanding how to properly structure this exact answer is exactly what separates an average student from a university topper. Right, let's dive into this.
Here is our synopsis for today. We have the introduction, followed by Part 1 on delivery of goods. Then we'll cover the statutory rules, move to Part 2 on acceptance of goods, discuss the mandatory case laws, and finally the conclusion. Let me give you a crucial exam tip right now. Outlining this exact structural framework on page 1 of your answer script guarantees a remarkably strong first impression with the KSLU evaluator.
Starting with Section 1, the Introduction to the Sale of Goods Act, 1930.
Now, the performance of a contract of sale fundamentally rests on two concurrent pillars: delivery of the goods by the seller and acceptance by the buyer. Look at this definition. Delivery, under Section 2, subsection 2, means the voluntary transfer of possession from seller to buyer. I want you to write this precisely in your booklets, but more importantly, literally instruct your pens to underline the words voluntary transfer to secure maximum marks. You see, if the transfer is forced or perhaps accidental, well, it is simply not delivery in the eyes of the law.
Moving on, the law is practical. It recognizes that physical movement isn't always possible. So we have three modes of delivery. First up is actual delivery. This is just the literal physical transfer of goods from hand to hand. Second is symbolic delivery, which is the delivery of a key or a document. Think of a heavy warehouse store. Handing over that warehouse key is a legally binding symbolic delivery in commercial transactions. And third, we have constructive delivery. This is a change in legal possession without any actual physical transfer taking place at all.
Let's move straight into the rules regarding delivery. These are the strict statutory provisions you'll need for a solid 16-mark answer.
We are now at the absolute core of your essay. There are 9 statutory rules you must detail. And let me tell you, evaluators are scanning your paper specifically for these exact section numbers. Let's examine rules 1 through 3. Rule 1. Delivery and payment are concurrent under Section 32. What does this mean? It means the seller's readiness to deliver must perfectly mirror the buyer's readiness to pay. Rule 2. Delivery as per contract under Section 31. The seller absolutely must deliver the goods exactly as agreed. Rule 3. Place of delivery under Section 36. Delivery has to happen at the agreed place, or if nothing was agreed upon, it defaults to the seller's place of business.
Okay, moving to Rules 4, 5, and 6. Rule 4 is about the time of delivery. If the time isn't explicitly specified, it must be completed within a reasonable time. Now, Rule 5 is critical. Goods in possession of a third party, under Section 36, subsection 3. Delivery occurs only when that third party legally acknowledges the buyer's right to the goods. Listen carefully. I want you to place heavy emphasis on this section in your notes. Third-party acknowledgement is the absolute legal trigger for valid delivery here. Finally, Rule 6, part delivery under Section 34. Delivering just a portion of the goods may actually amount to the delivery of the whole, provided that was the clear mutual intention of the parties.
Next up is Rule 7, which covers the delivery of wrong quantity under Section 37. If the seller delivers too much or maybe too little, the buyer is actually armed with 3 distinct choices. Choice 1, reject the goods entirely. Choice 2, accept the correct agreed quantity and reject the rest. Or Choice 3, accept the excess and pay for it at the contract rate. Now, advising you purely from an examination standpoint, listing these exactly as structured, bulleted steps on your answer script, that is highly effective for clarity and will definitely fetch you marks.
Concluding our rules of delivery, we have Rules 8 and 9. Rule 8 covers installment delivery under Section 38. This is strictly not allowed unless it's explicitly agreed upon by the buyer. And Rule 9, expenses of delivery under Section 36, subsection 5. Who actually pays to get the goods ready while the seller bears the cost of putting the goods in a deliverable state? Explicitly state in your answer that this financial burden defaults strictly to the seller, all right?
Right, let's transition to the second half of our question. Part 2. Acceptance of goods, its meaning and statutory effect.
In your examination booklet, I strongly advise you to visually divide your essay to mirror the prompt's 2-part structure. Make a bold, new heading for this section. So, what is the meaning of acceptance? Section 42 clearly states a buyer is deemed to have accepted goods under 3 strict conditions. 1. Intimation of acceptance, where the buyer expressly tells the seller they accept.
2. Acts inconsistent with the seller's ownership. This means using or reselling the goods. And 3. Retention without rejection. Basically, keeping the goods beyond a reasonable time without formally rejecting them. Now, you need to adopt a strict understanding here. By acting as the true owner, say by selling the goods to someone else, you legally destroy the original seller's ownership rights. And you simply cannot do that unless you have accepted the goods. Make sense?
But hold on, the buyer is actually protected by the right of examination under Section 41. The buyer has the fundamental right to inspect the goods before acceptance. This is absolutely crucial. Section 41 inspection is a protective legal shield. But look closely at the effect here. Once acceptance legally happens under Section 42, that shield drops. The buyer irrevocably loses the right to reject the goods entirely, and from that point on, can only sue to claim monetary damages.
Let's move to the case laws. These are the mandatory landmark judgments you must commit to memory.
Students, I need you to switch your focus completely right now. Quoting exact legal provisions gets you good marks, sure, but quoting these exact case laws, that is exactly what separates average marks from top KSLU marks. The first mandatory citation is Varley versus Whip. Read that loudly in your mind. In fact, I command you to draw a distinct box around this exact citation on your exam paper. Doing this instantly signals to the evaluator that you have a master's grasp of the jurisprudence.
Let us comprehensively break down Varley versus Whip. The facts. The buyer required an inspection of the goods before finalizing any acceptance. The ratio decidendi, which is the final verdict of the court, was clear. A buyer is absolutely not deemed to have accepted goods without inspection. And the absolute relevance of this case, why does it matter? Because it directly enforces the buyer's fundamental right under Section 41. It establishes that one cannot be forcefully deemed to have accepted goods until that Section 41 inspection right is fully honored by the seller. Write this logic down, step by step.
Our second landmark case is Hardy & Company versus Hillerns & Fowler. State this name deliberately in your writing. Again, please remember the strict formatting required for legal citations in a formal law examination. Underline this case name prominently for your 16-mark answer to capture the evaluator's attention.
Let's dissect the Hardy & Company case. The facts: the buyer engaged in using or reselling the goods in question. Now, the ratio decidendi here is profound. The court ruled that acceptance legally occurs the precise moment the buyer acts inconsistently with the seller's ownership. The relevance? It strictly applies the Section 42 rules of deemed acceptance, and this brilliantly illustrates why Section 42 exists. By reselling the items, by acting inconsistently with the seller's original title, the buyer legally triggered Section 42 acceptance, completely waiving away their right to outright rejection.
Finally, we arrive at the conclusion: the essential elements of contract performance.
Listen, after writing a lengthy, highly technical essay, you must provide a concise, powerful concluding paragraph. Something like this. Delivery and acceptance are essential elements in the performance of a sale contract. Clear rules ensure smooth transfer of possession and ownership, protecting both buyer and seller. Wrapping up a long, complex answer with this exact conclusive statement leaves the evaluator deeply satisfied. It clearly shows you understand the broader commercial intent behind the 1930 Act.
Before we close this explainer, I want to leave you with a provocative KSU-style exam question to critically test your understanding. If a buyer resells goods before inspecting them, which section ultimately governs their actions? Section 41 or Section 42? Think deeply about the intersection between the right of inspection and deemed acceptance by inconsistent acts. Master that intersection, and you will master the Sale of Goods Act. Study hard, review these concepts, and prepare your answers diligently. Good luck!